A Probate Guide. Chapter 1. You can avoid most of probate. The probate process. Probate is the legal process used to settle an individual's estate after they pass on. An individual's assets and liabilities are identified. All his or her debts are paid, including taxes, then the administrators, attorneys, are paid. The remaining assets, if any, are distributed to the heirs as stated in the will. If there is no will, benefits are paid in accordance with state law. Probate takes time to resolve and administrative costs could go 10% or even higher of the estate. They dragged out Marilyn Monroe's probate process until all her estate was used up in lawyers' fees. The other big problem with probate is that it is public record. Anyone is allowed to see what assets the decedent had and who inherits what. Probate is a county court process which oversees your last will and testament and strives to administer it properly. However, it has a bad rap, generally because there's lots of room for abuse. A lawyer can drag it out, hiring extra workers, doing a myriad of tasks like accounting, appraisal, liquidating, managing, selling, etc., all of which cost money and deplete the estate, not to mention the wear and tear on your nerves as the estate goes unresolved for several months, even up to several years in some cases. Probate can be as simple as filing with the court and receiving the proper certification to administer the will, or it can get very complicated, especially if there's a sizable estate and the person died without leaving a will. The catch-22 of safe deposit boxes are that if they are not jointly owned, they will be sealed upon death until probate gets at them, so don't put important papers in there unless your spouse is a CO renter. If the value of the estate falls below a certain minimum, something like $10,000 to $100,000 depending on the state, you can forego probate entirely and go through a simpler process called small estates settlement. The bad rap of probate comes from expenses like lawyers' fees, court costs, filing fees, appraisers' fees, brokers' fees, etc. HALT, the anti-probate organization referred to below, estimates that between 8 to 10% of the estate on average is lost through the probate process. There are some bitter people out there that have lost it all through probate. Another bummer of probate is that your estate becomes public knowledge. Anybody can look through the records of your assets. This does not happen with a living trust. If you're a business owner, probate could mess it up if several people want a piece of the business, so take care of it before death. The assets are frozen while the probate process takes place, a year or more, though some courts may give the spouse a small allowance during that time. Basically, the probate process involves finding all your assets and then using them to pay for your liabilities. Utility bills, car payments, mortgage payments, credit card payments, medical bills, funeral expenses. No one is legally obligated to pay another person's debts unless it was a CO-signed loan/credit card. If debts are more than the estate is worth, the court tries to allocate the funds fairly. When someone dies, they owe taxes on whatever income they earned during the taxable year in which they died. The executor is responsible for filing an individual tax return for the deceased. The spouse can file a joint tax return if he/she wants. A separate income tax must be paid on all money-made business/investments which are the property of the estate. If you start a joint bank account for your children, it's still considered part of your estate. If you're old, talk to your kids about your money situation. Talk to your parents about your inheritance. If you give enough money away, you can qualify for Medicaid and to live in a nursing home for free. Charitable gifts to a charity, religion, or educational institution are not taxed. Life insurance becomes part of the estate, therefore, it's subject to federal estate taxes, but you can change your life insurance to a life insurance trust, thereby keeping those funds out of your estate. If you receive property as part of an inheritance and sell it, the gain can be taxable. After everything has been assessed and debts, claims, and taxes have been paid, the executor can distribute the assets according to the will or according to intestate laws if there was no will. When this is done, a final closing statement is filed. In some states, if some items you'll inherit are worth under a certain amount of money, you can file a probate affidavit to get those items now. In some states, if the estate is under a certain amount, there is no formal court process. The judge just signs it off. Check out number 346.730 at the library for probate books. Avoiding probate. The objective is to avoid probate for your heirs. Give away most of your stuff now. Put your house, car, and bank accounts into joint ownership so when you pass, ownership goes directly to the co-owner. Anything in your estate that's directly signed to a specific person in the event of your death, like your life insurance policy, goes directly to that person without probate. Joint ownership is huge because when one owner dies, the other owner takes full ownership without probate. There are several techniques or procedures you could do to possibly avoid probate on some or all of your property. I will state them now very briefly, discuss them a little bit later, but your responsibility is to learn about them fully by going to other reference material, experts in the field and the creators/sellers of these instruments. Have an estate valued at under the state value in order for probate to occur. This value is somewhere between $10,000 to $100,000. Have all your major assets either in joint ownership or accompanied with a power of attorney form or something similar that states that when you die, this other person takes ownership of this asset. There are probatable and non-probatable assets. Probatable assets include titled property solely owned by the deceased. If the deceased plans ahead, his or her assets can be placed entirely in non-probate form. The following instruments can be used to avoid probate at death. Simply set them up to pay off to your heirs directly in the event of your death. In my opinion, the easiest way to avoid probate is to sign over everything now to your heirs as long as you trust them not to leave you out in the cold if need be. Another way is to put your accounts and house into joint ownership with your heirs. A big way to avoid probate at death is to give away stuff now or make up payable/transfer on death forms for your titled assets. Ask your lawyer about it or buy the book 8 Ways to Avoid Probate by Nalo Press, 800-992-6656, nalo.com. Some probate avoidance methods are: transfer real estate to a living trust. Name a payable on death beneficiary for bank accounts and CDs. Name a transfer on death beneficiary for stocks and bonds. Register ownership of government bonds in beneficiary form. Register vehicles in transfer on death forms. Name a beneficiary to inherit your retirement accounts, IRAs, and 401(k)s on death. Put some property in joint ownership. Create living trusts. Most states have state law exemptions which allow a certain amount of money to be taken out of the estate and passed on to heirs immediately upon death without having to wait for the final results of probate court, which typically takes 12 to 18 months. Simply get rid of what you own now, give away cash and sign over valuables to your kids. A trust is simply an instrument where you can name yourself or a trusted friend as the trustee, then move some property into it like real estate or cash and write up provisions about what you want done with it upon your death. The procedure is that the ownership documents for things like cars, houses, stocks, etc. are transferred into the trust, and other things like books, furniture, etc. are listed as part of the trust. Put everything you own into these trusts, then avoid probate. You don't even need a will for them since they're already self-contained. Beware that some states charge a transfer tax for transferring real estate from your name to the trust even if you're the trustee. Check with your county tax assessor/recorder's office for details. Another disadvantage of trusts is that creditors can file a claim against it almost indefinitely, while if your assets are in probate, creditors only have a certain amount of time to file a claim against you, usually 6 months. Another option is to create a foundation. With these instruments, you can donate things like a house, etc., but still retain use of them. They get complicated. Consult an expert lawyer about them. Joint accounts or joint ownership of anything with your spouse doesn't avoid probate, it just postpones it until the spouse dies. Life insurance payouts directly to the beneficiary without probate. By making a gift of your life insurance policy while you're alive, it will not be considered part of your estate when you die. The catch is that you have to live for 3 years after you give it away in order that it not be considered part of your estate. It is considered part of the $11,000 annual gift exclusion allowance. Payable on death bank accounts, also known as Totten trusts or the poor man's trust, are merely bank accounts or government securities where you ask for a form where you sign to transfer the account to one beneficiary only upon your death. Just ask about them at the bank. There's no probate involved. U.S. savings bonds can be made payable directly to someone else to avoid it going through probate on death. Annuities don't go through probate. Stocks, bonds, and mutual funds have a transfer of death registration called a Directed Beneficiary Arrangement/DBA, where you can sign a form that directly transfers any of these instruments to a beneficiary on death without probate. Ask your investment companies for these forms. You can sign the benefits from your pension plan and retirement savings plan, things like IRAs, KIOs, etc., over to a beneficiary without having to go through probate. In some states, you can sign a form at the Department of Motor Vehicles which will legally transfer the ownership of your vehicle, to a beneficiary at your death. Finally, a solution some people choose is to expatriate from the U.S., which means to move to another country, renounce American citizenship and get foreign citizenship. There is an exit tax on estates valued at over whatever the current value is, but if you can get the money out either electronically or in cash like in a boat or plane, more power to you. I discuss this option more in another section. Check out 346.730 at your library for probate books. Inheritance loan/probate cash advance. Prove to these people that you are soon to inherit money and they give you a loan. heiradvance.com. estatefinance.com. Probate websites. Try number 346.71-73, Family Law, or KE 5974 and KF 750 at the Library for Books on Estate Planning. 1800probate.com. abanet.org/public.html, public resources. ca-probate.com, California Probate, list of probate attorneys in all of USA. closeprobate.com, California. estateattorney.com.